What if one of the world's most recognizable royals accused one of Britain's most powerful newspaper publishers of secretly invading his private life for decades? That question sits at the heart of a lawsuit that has pulled back the curtain on the hidden relationship between the press and the people it covers. For years, the tabloid press and the British royal family have existed in an uneasy, symbiotic tension, one that has occasionally spilled into public view and occasionally ended in tragedy. Now, that tension has landed in a London courtroom, where a duke, a pop icon, and a handful of other well-known figures have accused a major newspaper group of using unlawful methods to dig into their most private moments. The publisher denies every word of it. Today, we're breaking down every major event that led to one of the biggest media lawsuits involving the British royal family. Prince Harry, formerly known as the Duke of Sussex, is the younger son of King Charles III and the late Princess Diana. Since stepping back from official royal duties in 2020, he has built a public life outside the traditional boundaries of the monarchy, and along the way, he has become one of the most prominent and most litigious critics of the British tabloid press. Associated Newspapers Limited, or A&L, is one of the United Kingdom's largest newspaper publishers. It owns the DailyMail, the Mail on Sunday, and the online outlet Mail Online, publications that reach millions of readers every day and that have, for decades, played an outsized role in shaping how the British public sees the royal family, celebrities, and public figures more broadly. The Daily Mail in particular is often described as one of the most influential newspapers in the country, capable of setting the agenda for other outlets and even shaping political conversation. So why has this specific lawsuit drawn attention far beyond Britain's borders? Because it isn't simply a dispute about a handful of unflattering headlines. It's a case that asks whether one of the country's most trusted media institutions engaged in a sustained, secret campaign of unlawful surveillance, and whether the country's legal system will hold it accountable even decades after the alleged activity took place. To understand this case, it helps to understand the relationship between Prince Harry and the British press, a relationship that has never been simple and rarely been warm. Harry grew up almost entirely within the public eye. As a child, he was photographed constantly, his movements tracked and reported by a press pack that treated the young royals as both national symbols and marketable commodities. That intense scrutiny took on a darker cast in 1997, when his mother, Princess Diana, died in a car crash in Paris while being pursued by photographers. That event became a defining moment, not just for Harry personally, but for the broader debate in Britain about where legitimate public interest ends and invasive tabloid pursuit begins. In the years since, Harry has spoken openly, in interviews, in his memoir, and in court about what he describes as a lifetime of feeling hunted by sections of the press. He has said the experience left him deeply distrustful of tabloid journalism and convinced that some publishers were willing to cross legal and ethical lines to get a story. This lawsuit against Associated Newspapers is not his first legal fight over press conduct, and understanding the ones that came before helps explain why he pursued this case at all. In 2019, Harry joined a group action against Mirror Group newspapers, alleging that journalists there had used phone hacking and other unlawful techniques to gather information about him. That case went to trial in 2023, and Harry became the first senior member of the royal family to testify in a courtroom in more than a century. The court ultimately ruled in his favor, awarding him damages and later additional payments covering his legal costs. That same year, Harry was also part of a group action against News Group newspapers, the British arm of Rupert Murdoch's media empire, again alleging unlawful information gathering. Rather than proceeding to a full trial, News Group newspapers reached a settlement with Harry in 2025, reportedly involving a substantial payment. Those two cases set the stage for this one. Associated Newspapers had, notably, largely avoided being swept up in the broader phone hacking scandal that rocked British journalism starting in 2011, a scandal centered on the now-defunct News of the World, which led to its closure and to a sweeping public inquiry into press standards known as the Leveson Inquiry. For more than a decade, Associated Newspapers stood somewhat apart from that reckoning, even as rival publishers faced lawsuits, settlements, and public scrutiny over similar allegations. This lawsuit is, in many ways, the first time Associated Newspapers has faced this kind of allegation in open court at this scale. For Harry, It represents what he and his legal team describe as the final chapter in his long-running legal battle with the British tabloid press. It's also worth remembering that the relationship between the royal family and Britain's newspapers has never fit neatly into a single narrative. For generations, royal correspondence and palace communications teams have operated in a kind of uneasy partnership, one where access and cooperation could be traded for coverage, but where the boundaries of that arrangement were rarely written down and often tested. Harry has spoken about growing up watching the dynamic play out around him, and about concluding, especially after his mother's death, that some parts of the press were willing to go to dangerous lengths in pursuit of a story. That conviction has shaped nearly every public decision he has made since leaving official royal duties, from his choice to speak openly about his mental health to his decision, again and again, to pursue these publishers through the courts rather than simply move on. So what exactly is being alleged here? It's important to be precise, because these are, at this stage, allegations, claims made by one side that a court has not yet fully resolved. Prince Harry filed this lawsuit in October 2022 alongside 6 other prominent claimants: musician Elton John, his husband David Furnish, actresses Elizabeth Hurley and Sadie Frost, anti-racism campaigner Doreen Lawrence, and former Liberal Democrat politician Simon Hughes. Together, they allege that Associated newspapers engaged in a systematic and sustained campaign of unlawful information gathering, stretching across roughly 3 decades, from the early 1990s to the 2010s. Specifically, the claimants allege that journalists and people working on the publisher's behalf hired private investigators to plant listening devices in homes and vehicles, tapped or intercepted landline telephone calls, accessed voicemail messages without authorization, obtained private medical records, travel itineraries, and phone numbers through deception, sometimes by impersonating other people to extract information. Harry's individual claim reportedly centers on a set of roughly a dozen articles published between 2001 and 2013, largely authored by 2 Associated journalists. His lawyers argue those stories could only have been produced using information obtained through unlawful means, rather than through legitimate reporting. Why does this matter so much? Because if proven, these allegations would mean that one of Britain's most read newspaper groups broke the law, repeatedly and knowingly, to produce stories about some of the country's most recognizable public figures, and that it did so for years while publicly denying any wrongdoing. That is a serious accusation for any media organization, and it strikes at the heart of the trust that's supposed to exist between the press and the public it serves. But it is critical to underline, these are claims made by the claimants. Associated newspapers disputes them entirely, and it is up to the court to determine what actually happened. Associated newspapers has not stayed quiet in the face of these accusations. The company has firmly and repeatedly denied every allegation, describing the claims in court filings as preposterous smears. Its legal team, led by barrister Anthony White, has argued that the case against it is built on inference and speculation rather than solid evidence. In court, White characterized the claimant's approach as an exercise in connecting alleged private investigator payments to specific articles without any direct proof that unlawful methods were actually used. He suggested the claimants had, in his words, jumped to conclusions based on incomplete evidence rather than facts that could withstand scrutiny. Associated's central alternative explanation is straightforward. Many of the stories in question, the publisher argues, came from legitimate sources, including friends, associates, and contacts close to the claimants who were willing to share information, sometimes attributed in print simply as a friend of the individual involved. The company argues that just because a source is described vaguely doesn't mean the information was obtained illegally. The publisher has also raised current and former staff as witnesses, including editors and reporters with decades of experience at the company, who are expected to testify about how specific stories were actually sourced and to dispute claims of unlawful conduct. Finally, Associated Newspapers has raised a significant legal defense. It argues that even if some of the underlying claims were true, they were brought far too late, because the alleged conduct dates back as far as 1993, and the lawsuit wasn't filed until 2022. The publisher contends the claims fall outside the legal time limits, known as limitation periods, that normally apply to civil claims in the UK. It's a defense that, if successful, could end the case regardless of what actually happened decades ago. We'll explain exactly what that means and why it matters so much shortly. Let's walk through how this case unfolded step by step. The story arguably begins in 2021, when a private investigator named Gavin Burrows came forward. Burrows claimed he had carried out hundreds of jobs for the Daily Mail between 2000 and 2005, and said that Harry, Elton John, David Furnish, Elizabeth Hurley, and Sadie Frost were among his targets. According to the claimant's legal team, it was this information that first alerted them that they may have been victims of unlawful surveillance. Notably, Burrows later filed a separate sworn statement disputing his own earlier claims, denying that he had ever been hired by Associated Newspapers to carry out unlawful work, a contradiction that itself became a point of contention in the case. In October 2022, Harry and the other 6 claimants formally filed their lawsuit against Associated Newspapers Limited at the High Court in London. In the years that followed, the case moved through a series of preliminary hearings. Associated Newspapers attempted to have the case thrown out early, arguing that the claims were filed too late under the relevant limitation periods. The judge overseeing the case, Mr. Justice Matthew Nicklin, declined to dismiss the case on those grounds outright, but made clear that the limitation offense would be revisited once the court had heard the full evidence. The trial itself began on January 19, 2026 at the High Court in London, and was expected to run for approximately 9 to 10 weeks. It became one of the most closely watched civil trials in recent British legal history, drawing international media coverage and public curiosity in equal measure. On January 21, 2026, PrinceHarry took the witness stand for the second time in his ongoing legal battles with the tabloid press, the first being his 2023 testimony in the Mirror Group case. He was cross-examined by Associated's barrister, Anthony White, who challenged the idea that journalists had used unlawful methods, instead suggesting that Harry's own social circle may have been the source of information published about him. Harry firmly disputed that suggestion. Throughout the trial, the court heard testimony from a range of witnesses, the claimants themselves, current and former Associated journalists, and evidence relating to private investigators allegedly used by the publisher. By the end of March 2026, closing arguments had concluded, and Justice Nicklin indicated that reaching a verdict would take considerable time given the scope and complexity of the evidence presented over the trial's 9 weeks. As of this recording, a written ruling is anticipated in the coming days, with some reports suggesting a verdict date around July 7, 2026, though as with any complex civil case, that timeline could shift. Whatever the outcome, an appeal from either side remains a realistic possibility, meaning this legal saga may not be fully over even once Justice Nicklin delivers his decision. Over the course of the trial, both sides presented extensive evidence to support their positions, without ever tipping the scales toward a certain outcome ahead of the judge's ruling. For the claimants, evidence included personal testimony from Harry and his fellow plaintiffs about specific articles they believe were the product of unlawful information gathering. Their legal team, led by barrister David Sherburne, who also represented Harry in his successful case against Mirror Group newspapers, argued that a pattern existed across decades of alleged private investigator use, and pointed to what he described as a culture within Associated Newspapers that permitted or even encouraged questionable reporting practices. Sherburne also argued that the company's internal record-keeping made it difficult for claimants to prove their case with complete certainty, describing what he called significant gaps in the available documentation. The claimants also relied on testimony connected to private investigators alleged to have worked for the publisher, including the disputed and later retracted statements from Gavin Burrows. For its part, Associated Newspapers called numerous current and former journalists and editors to testify about how individual stories were actually researched and sourced. The company's legal team worked to systematically challenge the claimants' timeline and inferences, arguing that publicly available information, tips from acquaintances, and standard journalistic practices explain the stories in question, not illegal surveillance. It's worth noting that no verdict has yet been delivered on any of this evidence. What we do know is that Justice Nicklin heard testimony from a wide range of individuals over roughly 9 weeks, and that his eventual written ruling will need to weigh competing and largely irreconcilable accounts of what happened. Part of what makes this case unusually difficult to adjudicate is the sheer passage of time. Some of the events at the center of the dispute allegedly occurred more than 30 years ago, which means memories have faded, some of the journalists and sources involved are no longer alive or able to testify, and documentation that might otherwise settle the matter definitively may simply no longer exist. The claimants argue that this lack of documentation is itself suspicious, pointing to what they describe as gaps in the company's records. Associated Newspapers, in turn, argues that the absence of proof is not evidence of wrongdoing. It's simply the natural result of decades passing since the events in question. That disagreement over how to interpret missing evidence runs through nearly every part of this trial, and it's one of the central challenges Justice Nicklin will have to resolve in his written judgment. This case involves several legal concepts that might sound complicated, but are worth breaking down simply, because they're central to understanding what's actually at stake. First, what does unlawful information gathering mean in a legal sense? It's a broad term that can include activities like intercepting private phone calls or voicemails without consent using hidden recording devices, and obtaining confidential records, such as medical or financial information, through deception or impersonation. Under UK law, these actions can breach a person's right to privacy, and in some cases may also constitute criminal offenses. Second, privacy law in the United Kingdom. The UK doesn't have a single, standalone right to privacy law in the way some other countries do. Instead, protections come from a mix of sources. The Human Rights Act, which incorporates the European Convention on Human Rights Guarantee of Respect for Private and Family Life, along with data protection legislation, and long-standing legal principles around confidential information. When someone brings a case like this one, they're often relying on a combination of these legal tools to argue that their privacy was unlawfully violated. Third, and perhaps most pivotal to this particular case, limitation periods. In English law, most civil claims must be brought within a set number of years from when a harmful act occurred, or from when the claimant reasonably discovered it. This exists to ensure fairness, allowing cases to be resolved while evidence and memories are still fresh, and preventing people from facing legal claims indefinitely for events from the distant past. Associated Newspapers argues that because the alleged conduct in this case stretches back to 1993, and the lawsuit wasn't filed until 2022, the claims are simply too old to proceed, regardless of whether they might otherwise have merit. The claimants counter that they could not have reasonably known about the alleged unlawful activity until more recent revelations came to light, which is why the case wasn't brought sooner. How the judge resolves this question could be just as important as any of the underlying factual findings, because if the limitation defense succeeds, the case could be dismissed on those procedural grounds alone. Finally, there's the matter of precedent. Because Associated Newspapers had largely avoided the reputational fallout of the broader 2011 phone hacking scandal, a ruling against the company here could meaningfully reshape how it, and potentially other publishers, are viewed in relation to past reporting practices. A ruling in the publisher's favor, on the other hand, could reinforce the idea that without direct, verifiable proof, allegations of unlawful information gathering, however serious, cannot succeed in court. This case has generated significant reaction from multiple corners of British society and beyond. Media and legal commentators have been divided in their assessments. Some journalists and press freedom advocates have expressed concern about the broader implications for investigative journalism if courts begin treating vague or circumstantial evidence as sufficient to prove unlawful conduct by reporters. Others, particularly those who have followed the earlier Mirror Group and News Group cases closely, have suggested that the pattern of settlements and rulings against other publishers lends credibility to similar claims against Associated Newspapers. Royal commentators have focused heavily on what this case means for Harry personally, noting that a favorable ruling could offer him a sense of vindication after years of describing feelings of being unfairly targeted by the press. One royal editor, speaking to media ahead of the trial, suggested that a win for Harry would validate concerns he has voiced for years about press intrusion into his life. On social media, reactions have split largely along existing lines regarding public opinion of Prince Harry himself, with some users expressing strong support for his efforts to hold tabloid publishers accountable, and others questioning the wisdom or necessity of his continued legal battles with the press, particularly given the significant costs and years involved in pursuing them. Legal experts, meanwhile, have generally focused less on the personalities involved and more on the precedent question, watching closely to see how the judge handles the limitation period offense, since that ruling could have implications well beyond this specific case. There has also been a noticeable divide in how different sections of the British press have covered the trial itself. Some outlets have given the proceedings extensive, largely neutral day-by-day coverage, treating it as a significant national news story in its own right. Others, including titles with their own commercial and competitive interests in how Associated Newspapers is portrayed, have approached the coverage more cautiously. That dynamic has led some observers to note a certain irony. A trial about alleged press misconduct is itself being filtered through a press industry that has its own stakes in the outcome. For everyday readers trying to follow the case, that has made it especially important to separate verified courtroom testimony from commentary and speculation. Stepping back from the specific personalities involved, this case touches on questions that matter far beyond any single lawsuit. At its core, it's a case about the balance between freedom of the press and the right to privacy. A free press is essential to a functioning democracy. It holds power to account, informs the public, and plays a watchdog role that few other institutions can replicate. But that freedom isn't unlimited. Journalists and publishers, like anyone else, are expected to operate within the law. And when public interest in a story doesn't justify unlawful methods to obtain it, the tension between those two values comes into sharp focus. This case also raises important questions about celebrity journalism specifically. Public figures, by virtue of their fame, often face intense press scrutiny, and there's a long-standing debate about where the boundary lies between legitimate public interest and invasive intrusion into private life. This trial forces a British court to draw that line, at least for the specific claims before it. There's also the broader question of accountability. If a major, well-resourced media organization is found to have engaged in unlawful conduct over multiple decades, it raises uncomfortable questions about oversight within the newspaper industry and about how such conduct could continue for so long without earlier consequence. And finally, there's the question of what comes next. Whatever Justice Nicklin decides, the ruling could influence how future claims against media organizations are evaluated, how publishers structure their internal practices and record-keeping, and how public figures, royal or otherwise, approach disputes with the press going forward. There's also a financial dimension to this case that shouldn't be overlooked. Trials of this length and complexity are extraordinarily expensive to run for both sides. Millions of pounds in legal costs are reportedly at stake, and whichever side loses could be required to cover a significant portion of the other's expenses, on top of any damages awarded. That financial reality shapes the incentives for both claimants and publishers in cases like this one. It can deter individuals of more modest means from pursuing similar claims, while also putting pressure on media companies to settle rather than risk a prolonged and costly courtroom defeat. In that sense, this case is also, quietly, a story about who can actually afford to hold a powerful institution accountable in court and who cannot. As of this recording, the trial itself has concluded. 9 weeks of testimony wrapped up earlier this year, with closing arguments completed by the end of March 2026. Justice Matthew Nicklin has indicated that, given the scope of evidence involved, reaching a final written judgment would take considerable time. A verdict is expected soon, with some reporting pointing to early July 2026 as a likely date for the ruling to be delivered. Whatever the outcome, it's worth remembering that either side retains the option to appeal, meaning this case could continue in some form even after Justice Nicklin's decision is announced. No matter the result, this trial marks a conclusion, at least for now, of what has been described as a final major press-related lawsuit in Prince Harry's long-running legal campaign against sections of the British tabloid media. Over the course of this case, we've seen serious allegations of unlawful surveillance stretching back 3 decades, met with equally forceful denials from one of Britain's most influential publishers. We've seen a Duke take the witness stand for the second time in his ongoing battle with the tabloid press, and a media company fight to protect both its reputation and, if it comes to it, decades of previously undisclosed newsroom practices. What remains unresolved is, in many ways, the most important part of the story. Did Associated Newspapers actually break the law? And if so, will legal technicalities like limitation periods prevent that from ever being formally established? Those are questions only the court's final ruling can answer. Whether this lawsuit reshapes the relationship between powerful media organizations and public figures remains to be seen. As the legal battle continues, its outcome could influence journalism, privacy rights, and public accountability for years to come. Please don't forget to like, comment, and subscribe.